Today, an indictment was unsealed, charging Donald J. Trump with felony violations of our national security laws, as well as participating in a conspiracy to obstruct justice. This indictment was voted by a grand jury of citizens in the Southern District of Florida, and I invite everyone to read it in full to understand the scope and the gravity of the crimes charged. The men and women of the United States intelligence community and our armed forces dedicate their lives to protecting our nation and its people.
Welcome back to State Line Media. Let us dive in. Special Counsel Jack Smith has submitted a formal court document requiring Trump to provide sworn testimony, methodically tearing apart his immunity arguments and describing his actions as a criminal effort without precedent to undermine the outcome of the 2020 election. The document, precise in its use of evidence and sweeping in its reach, has dramatically changed the legal risk Trump faces and marks the moment his legal team has feared ever since Smith took on this role. Trump had persuaded himself that returning to the White House meant leaving his legal troubles behind. He told himself that the special counsel investigation would lose momentum on its own, that the legal cases would quietly disappear, and that the courts would eventually stop pursuing accountability against him. He went as far as making public declarations that he would eliminate Smith from his position the instant he won back the presidency.
From the DOJ back in 2025, Smith brought two cases against Donald Trump, one on election interference and the other related to classified documents.
I think we are facing an attack on the rule of law that is different in kind and scope to anything I've seen in my lifetime. One of the problems right today, besides the retribution prosecutions,
viewing the special counsel as nothing more than a political nuisance he could brush aside whenever he chose. But Smith turned out to be a far more capable and determined adversary than Trump had ever calculated. Smith showed from the beginning that he had a clear understanding of what Trump would attempt, and he took steps well in advance to make sure those attempts would not succeed. Smith wrapped up his investigative work, gathered his evidence into a comprehensive record, and submitted his court documents to the system before Trump had any opportunity to follow through on his stated intentions. And now, regardless of whether Trump attempts to remove Smith from his position, regardless of whether that attempt comes tomorrow or next week, the consequences are already locked in.
Two grand juries, the government tonight is showing its hand in its classified document case against former President Donald Trump, unsealing a 37-count indictment alleging that after leaving the White House, the special counsel, including photos of boxes stored in the open, some allegedly holding descriptions of foreign nuclear capabilities and U.S. defenses. The indictment also accusing the ex-president of showing national defense secrets to visitors at his New Jersey golf club, including military attack plans.
The filings exist within the court system. The formal accusations are part of the permanent public record. The request for Trump's testimony is already in front of federal judges who must now determine whether the sitting president of the United States can be legally required to answer questions under oath regarding his own alleged participation in a criminal conspiracy. This represents a constitutional confrontation happening in front of the country in real time, and it demands the kind of careful attention it deserves. The central question that Smith's filing puts before the court sounds straightforward on the surface, but carries profound implications for the future of American governance.
Now, until last week, no former president had ever been charged by the Justice Department, let alone accused of mishandling top secret information. The special counsel in this case, Jack Smith, who wants to bring the charges against him, says he is seeking a speedy trial. But speedy, when it comes to the federal court system, is, of course, a pretty relative term. It could be actually months before this actually even begins.
Can a sitting president be compelled to sit down under oath and answer for conduct that took place during his time in office? Or does holding the presidency provide him with a barrier that places him beyond the reach of legal accountability? Smith's position on this question is clear and carries serious consequences for Trump. A single body of law governs everyone who lives in this country, and the person occupying the Oval Office is not exempt from it.
Donald Trump indicted on 4 federal felony counts. The former president accused of criminally assaulting the bedrock of American democracy.
I think we have a very powerful statement from the special counsel of how the former president really tried to undermine our democracy from within.
You know, the Department of Justice indicted Mr. Trump over his alleged effort to overturn the 2020 election results and that he knowingly pushed lies about the election leading to the insurrection.
The filing makes the case that what Trump did to try to reverse the outcome of the 2020 election had nothing to do with his official duties as president. It was a private political operation carried out for the purpose of keeping himself in power after voters had chosen someone else. Because that conduct was not official in nature, Smith argues, Trump can face prosecution for it and can be ordered to answer questions about it in a formal legal setting. That determination now rests with the courts. What separates this filing from ordinary legal documents is the level of specificity Smith brings to the allegations against Trump.
And we have seen judges across the country say they can't trust prosecutors anymore. And that has such a cascading effect on any sort of case. And, you know, I can't count how many opinions, but one opinion like that in my career would have been seismic. People would not know what to do if a court said, you know, trust that's been built over generations has been lost in days, right? And that's happening every day. And so regardless of what you think politically, they're just not effective at doing their job anymore.
There are no vague accusations here, no broad claims unsupported by underlying facts, no general assertions about election irregularities intended to create an impression rather than prove a case. Smith lays out with precise detail exactly what actions Trump took, the specific sequence in which he took them, the individuals he involved, and the methods he used to carry out what Smith describes as a coordinated criminal plan. Among the evidence Smith references are recordings in which Trump can be heard in his own voice directing others to locate additional votes, a form of evidence that leaves essentially no room for reinterpretation or denial. Smith also references a collection of documents that show Trump actively overseeing the false elector operation, establishing through a documentary record that this was not a spontaneous development, but a deliberately conceived and systematically executed scheme. Supporting all of this is testimony from individuals who were physically present during the planning discussions, people who can speak from direct personal experience about what they heard and witnessed as Trump worked to overturn the election. Layered on top of that are communications between Trump and the people working with him that show a shared understanding of what they were trying to accomplish and a common intent to carry it out. The element of Smith's strategy that carries perhaps the greatest tactical weight is his formal request that the court require Trump to testify under oath. By making this request, Smith is communicating to the court that the evidence he has compiled is not merely sufficient, but so compelling that hearing directly from Trump himself has become a necessary part of establishing the full truth of what happened. The stated purpose is to resolve factual questions that documentary evidence alone cannot fully answer and to give Trump the opportunity to provide his own account of his actions on the record. But the practical effect of this request is to place Trump in a position from which there is no comfortable exit. If Trump sits down and tells the truth, he confirms the conduct that Smith has documented and effectively hands prosecutors additional evidence to use against him. If Trump tells a version of events that conflicts with the documented record, he exposes himself to liability for making false statements under oath. If Trump declines to testify altogether, that refusal creates its own set of legal and political problems and allows the court to treat his silence as something worth noting. Smith has constructed a situation in which every path available to Trump carries serious costs, and that reflects a level of legal strategy that is difficult to overstate. The moment Smith chose to file these documents is as important to understanding what is happening as the substance of the documents themselves. Trump arrived back at the White House carrying the assumption that the legal environment had fundamentally changed in his favor, that cases which had once threatened him were now behind him, that the window for meaningful legal accountability had closed. Smith's filing destroyed that assumption in a single stroke. It forced back into active consideration every legal question Trump believed had been resolved, and it did so through a formal court submission that the judicial system is obligated to take seriously. Federal courts do not have the option of declining to engage with evidence of this volume and specificity. They cannot disregard a formally submitted demand for testimony backed by the kind of documentary record Smith has built. From the moment this filing entered the system, Trump has been required to manage a serious legal crisis. At the same time, he is attempting to carry out the functions of the presidency, and that combination of pressures is going to define the early period of his administration in ways he did not anticipate. The foundation of Smith's filing is built on evidence of a kind that makes it particularly difficult to challenge or explain away. This is not a case constructed from the accounts of a single source whose motivations might be questioned. This is a case assembled from multiple independent categories of evidence, each of which supports and reinforces the others. The recordings capture Trump's actual voice, in his own words, directing the people around him to take actions consistent with what Smith describes as a criminal plan. The documents create a paper trail that traces the development of the false elector scheme from its earliest stages to its execution, showing at each step that Trump was not a distant or uninvolved figure, but someone actively directing the effort. The witness accounts fill in the dimensions of the story that recordings and documents alone cannot fully convey, describing the texture of the conversations that took place and the atmosphere in which decisions were made. And the communications between Trump and those working alongside him demonstrate that there was a shared awareness among the participants of what they were collectively attempting to accomplish. When all of these categories of evidence are examined together, the picture they create is one that prosecutors rarely have the opportunity to present, a case where the conduct in question is documented from multiple independent directions simultaneously. Among all the evidence Smith has assembled, the recordings of Trump speaking in his own voice occupy a particularly important place. The reason is straightforward. A recording does not depend on the interpretation of a third party. It does not require a witness to recall a conversation from memory. It does not ask anyone to read between the lines of a written document. It captures what was actually said in the actual words used at the actual moment the words were spoken. When a judge or a jury listens to those recordings and hears Trump directing others to find votes, those words carry an evidentiary force that no defense argument can easily neutralize. Trump can claim after the fact that the recordings reflect something other than what they appear to reflect, that he was speaking loosely or hypothetically or in a context that changes the meaning of his words. But those arguments become progressively harder to sustain when multiple recordings from different moments all point in the same direction. The documentary evidence functions differently but with equal force. Where the recordings capture moments in time, the documents trace a trajectory. They show the false elector scheme not as something that materialized suddenly, but as something that was planned, organized, and carried out over a period of time with Trump's involvement at each stage. Emails reveal the discussions that took place among those coordinating the effort. Written strategies describe in explicit terms how the operation was intended to work and what outcome it was designed to produce. Notes from meetings document what was said when the people involved gathered to discuss their plans. Taken together, these documents make it impossible to characterize what happened as a spontaneous reaction to circumstances or as the independent initiative of subordinates acting without direction from above. They establish deliberate, organized conduct with a clear purpose. The testimony of witnesses who were personally present during the critical conversations adds a dimension to the case that no document or recording can fully replicate. These individuals can describe what it felt like to be in the room, how Trump responded to questions or objections, what the atmosphere was like as the planning unfolded. They can speak to things that were said informally in moments when no one expected a record to be made, and when multiple witnesses who were present at different times and in different settings all describe a consistent version of events, the cumulative weight of their testimony becomes very difficult to undermine. A defense attorney working against a single witness has tools available. A defense attorney working against multiple witnesses who independently corroborate each other faces a fundamentally different challenge. The documented efforts to pressure state officials represent some of the most legally serious conduct Smith's filing addresses. What took place was not a single conversation or a passing remark. It was an extended campaign in which Trump personally contacted governors, secretaries of state, and other officials responsible for the administration of elections and pressed them to do things that would have required them to abandon their legal duties. He asked them to identify votes that had not actually been cast for him, He asked them to reverse results that had been certified through proper legal processes. He pushed them to take actions that would have placed their own state's electoral outcomes in service of his personal political interests rather than the will of their state's voters. This conduct, sustained and systematic as it was, falls squarely within the definition of a conspiracy to interfere with the lawful functioning of the federal government. And Smith has assembled the communications, records, and witness accounts needed to document every significant element of it. The exchanges between Trump and Vice President Pence that Smith's filing addresses are significant for a specific legal reason. They show Trump asking Pence to do something that Pence did not have the legal authority to do. The role of the vice president in the certification process is defined by law, and that definition does not include the authority to reject electoral votes certified by the states. Trump apparently believed or chose to act as though he believed that Pence could simply decline to count certain states' votes and on that basis declare Trump the winner of the election. That is not what the law provides. Pence's obligation under the Electoral Count Act was to count the votes as the states had certified them, not to filter them through a judgment about whether their outcomes should stand. Trump's sustained pressure on Pence to act contrary to that legal obligation was itself an attempt to subvert the lawful process by which presidential elections are decided. And the evidence Smith has gathered shows not only that this pressure occurred, but that Trump had reason to understand that what he was asking Pence to do was not legally sanctioned. The immunity defense that Trump has consistently presented as his strongest protection against legal accountability has been directly and specifically addressed by Smith's filing. The argument Trump has advanced is that his status as president at the time of the conduct in question shields him from prosecution for anything that occurred during his time in office. Smith's response to this argument is precise. The conduct at issue was not carried out in Trump's capacity as president performing the functions of the executive branch. It was carried out in Trump's capacity as a political candidate attempting to retain power after losing an election. The distinction matters enormously under the law. Presidential immunity exists to protect the exercise of official governmental authority, not to provide cover for private political activity that happens to take place while someone holds the office. By arguing that Trump was acting as a candidate rather than as a president when he engaged in the conduct Smith describes, the filing attempts to establish that the immunity shield simply does not reach what Trump did. If courts accept that framework, the principal defense Trump has been relying on collapses, and he faces accountability as a private individual would. One of the most consequential aspects of Smith's approach is the timing with which he acted. By completing his work and placing his filings into the court system before Trump had any opportunity to act against him, Smith ensured that the evidence he compiled and the legal arguments he developed are now part of a permanent institutional record that exists independent of his own continued involvement. Trump can pursue whatever personnel decisions he chooses with respect to Smith's position, but those decisions cannot reach back and remove from the court system the documents that are already there. The allegations are on the public record. The evidence has been formally presented. The request for Trump's testimony is before the courts. None of that changes based on what happens to Smith personally. The legal questions this filing raises extend well beyond the facts of Trump's individual situation. If the courts agree with Smith's interpretation of the immunity doctrine, the implications will be felt by every future president. A ruling that presidential immunity does not extend to unofficial political conduct would establish that holding the presidency does not provide unlimited protection from legal accountability for everything a president does during their time in office. That would be a significant development in constitutional law, one that would shape the understanding of presidential power and its limits for the foreseeable future. The choice Trump now faces regarding testimony is one that offers no clearly safe option. Testifying under oath creates the risk of confirming through his own words the conduct that Smith has already documented through independent evidence. Declining to testify creates legal consequences of its own and invites the kind of public and judicial inference that tends to follow an unexplained refusal to answer questions under oath. Challenging the demand through the appellate process buys time but does not make the underlying evidence go away. If a court ultimately issues an order requiring Trump's testimony and he declines to comply, that refusal becomes a contempt matter with its own set of legal consequences. There is no path through this situation that does not carry meaningful risk, and that reflects the degree to which Smith's filing has succeeded in placing Trump in genuinely difficult legal territory. The period immediately ahead will be defined by the judicial proceedings set in motion by Smith's filing. Lawyers on both sides will submit written arguments. Judges will examine the evidence and the legal questions it raises. Oral arguments will eventually take place at which each side will make its case directly to the court. The decisions that result from those proceedings will not merely determine what happens to Trump personally. They will answer questions about the relationship between the presidency and the rule of law that have implications for American constitutional governance far beyond the present moment. And Congress will inevitably become part of the picture as well, as legislators from both parties find themselves required to take positions on whether a president should be legally compelled to answer for conduct of the kind Smith has documented. Jack Smith's formal filing seeking Trump's sworn testimony, built on a comprehensive evidentiary record documenting an effort to reverse the outcome of the 2020 election, has placed Trump's legal situation at one of its most serious and consequential points. If the courts grant Smith's request and order Trump to testify, the country will witness something that has never occurred before in its history: a sitting president formally compelled to answer under oath in connection with a criminal proceeding. Whatever the courts ultimately decide, the outcome will carry lasting meaning for whether the principle that no person is above the law applies with equal force to those who hold the highest office in the country. For more breaking news and in-depth coverage, like and subscribe to Stateline Media. Thanks for watching.